Sorry I missed your opening statements. I had a live radio Q&A I had to do at that time. I'm going to start with Judge Davis. During your confirmation hearing, you said that you were, that's when you were district judge, that you were neither an originalist or textualist. You also suggested that you do not have judicial philosophy. Now that you've served as a district judge and a magistrate judge, do you have a judicial philosophy or an approach to deciding cases?
Thank you for the Thank you for the question, Ranking Member Grassley. I would say that I still don't subscribe to any particular label, but I do recognize that depending on the type of case, there is Supreme Court precedent for the way in which a particular case should be analyzed. So, for instance, I'll start off by saying, with respect to textualists, I think it was Justice Kagan who said that we're essentially all textualists from the perspective that when you're looking at a statute or the Constitution, we start with the words that are on the paper, the text that is there. The Supreme Court has also indicated in certain areas looking at the original meaning is also important. For instance, in Heller, that is exactly what the Supreme Court said, and also in Crawford in dealing with confrontation clause issues. And so it's always my goal and intention to follow the precedent in terms of the way in which analysis should be undertaken.
Ms. Friedman, your career has focused heavily on habeas corpus, I've been informed. The Third Circuit has many cases involving corporate law, security litigation, antitrust, administrative law. And so I'm interested to know how you would handle other legal issues. Have you handled cases in any of those areas that I just described or areas that I didn't mention that you would probably think of? If not, can you tell us about your plan to become familiar with the areas of law besides habeas?
Thank you, Senator. In my 12 and a half years of service as a federal public defender, I have frequently encountered a variety of legal issues. I represent individuals who are challenging convictions and sentences that occurred in state court as well as federal court. And so I often need to study state law, state procedures, as well as substantive and procedural federal law. So those skills I would use, if confirmed, to review a variety of matters on the Court of Appeals. Additionally, as a judicial law clerk for 2 years, I worked on all manner of civil cases, including many of the types of cases that you mentioned in your question, Senator.
Okay, another question for you. You were interviewed on something called Doing Time podcast. And during the podcast, I quote you, "There is really very little in the law that is clean cut, and particularly constitutional law and federal statutes. There is vigorous debate over many of these issues. Oftentimes, I, meaning you, am 100% convinced that I'm right about how the law should be interpreted, and the prosecutors on the other side have the same level of confidence in their view, and we rely on the courts to end these disputes," end of quote. Do you think that you often disagreed over the meaning of federal law because of differences of judicial philosophy? And can you tell us what your judicial philosophy is and how you think about it should be interpreted? Law should be interpreted.
Thank you, Senator, for that question. In thinking back about the times in which opposing counsel and I have disagreed about matters of constitutional law, I think primarily it's because of our perspective as advocates for our particular clients. As an advocate for my clients' interests, I, of course, need to make the arguments that would benefit the client, and I use the boundaries of the law to make those arguments. And as I mentioned in the quote you read, there are gray areas, and we do rely on courts to resolve those neutrally and fairly after considering the arguments of the parties. In terms of judicial philosophy, I through my practice and my service as a law clerk, I've observed a methodology that supports the fair administration of justice, and that is the rigorous study of the law, scrupulous review of the factual record, and open-minded consideration of the parties' arguments. And if confirmed, I would also use open-minded consideration of my colleagues' viewpoints.
Okay, thank you.
Thank you, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. I just wanted to